Good afternoon, Your Honors.
Good afternoon.
I almost said good morning because I'm so used to being here in the morning. My name is Pat McNally. I'm a member of the Nashville Bar and have the pleasure of being here on behalf of Frank Fankam, who is also present in the courtroom with me. And I guess he would say he probably doesn't feel necessarily like it's a pleasure after having been convicted and is now on a period of probation, but we're grateful that he's able to attend today. I would like to reserve 3 minutes for rebuttal argument if it please the court. I think it's important to know a little bit about Mr. Fankam that's in the state's brief and a little bit in our brief before we get to the incident at hand here. In a sense, he's kind of the success story up until the conviction that occurred in Davidson County. He moved here from Cameroon. His family moved here from Cameroon, the west part of Africa, when he was 16 years of age. Being a very bright individual, but with limited English, his native language is French, he graduated from high school at age 16 before entering DuPage College, which is just on the outskirts of Chicago. They had moved to the suburbs of Chicago. He was there and he took classes trying to improve his English, as well as an interesting class called Assimilation into United States Culture. And then he transferred to Juliet College, junior college there, about 54 miles west of Chicago, played soccer, and got his nursing degree. His first job was at a hospital as a nurse in Chicago, and then he started to travel. But he wanted to go further. And interesting, I didn't know this, but interesting to me was here in Nashville, in Madison, just a little north of downtown Nashville there is the Middle Tennessee Anesthesiology School, or college. And it's the only certified school in the country where you can get a doctorate of nurse anesthetologist. I'll stumble on that word all through this, but please bear with me. Where you can actually get a doctorate in nursing on that to be an anesthesiologist, a nurse anesthesiologist, and he did that. And that was in January 2019 when he met. And I really ask the court's instruction. I will refer to the adult victim in this case as by her initials of DLR, her last name initials, rather than using her name if the court prefers. I will start using that in my practice of my briefs. I've noticed the trend. I always did it with juveniles or with children, but I've noticed in some of the recent opinions that the court are starting to do that now, and the state did it in their brief. But I'll refer to her as DLR or the accuser or prosecutrix, okay? Anyway, January 2019, both of them are starting at school there. And there's an orientation, and they meet and they socialize and everything of that nature and whatnot. And while they both had other relationships somewhat committed, they seemed to strike up a pretty close relationship. The state refers to it as kind of some kissing or some socializing, but truthfully, both of them admitted that they had been making out at public places. They had drank a lot, they had bar hopped a lot, they had socialized a lot, they had talked about their dreams and things of that nature. And this had been going on for quite a while because we started January 2019, and then we have this incident of September of 2020. There's no question both parties admit about the drinking together, the partying together, the talking a lot together, the flirtation together, and the making out at two public places in Nashville. Now, one thing that is in dispute, factually in dispute, is Mr. Fankam says that on 2 occasions they did have sexual intercourse at her place. She denies that. But she does admit that they did cuddle in her bedroom several times. She didn't know exactly how many times, but frequently they would get together at her apartment and they would cuddle and sleep in her bed and make out. Now, moving on, in September of 2020, September 27th of 2020, or actually September 26th of 2020, Mr. Fankam is out with some guys. He's at a hotel at a pool on top of one of these bars. We have bars with a pool on top of a hotel, and he's drinking with some friends. He puts out a Snapchat, and I had to learn about Snapchat, where you take a picture, you post it out there, and it's not directed necessarily to one individual, but it's out there. And in response, Miss DLR had said, "Hey guys, what are you doing? Zadie, you're looking good. Where are you guys?" And that's when he responded back and said, "Well, we're about to head down to Dogwood, another bar." And the two of them, and she's with her friend Macy. Macy and the accuser get together, and they meet Mr. Fankam and his friends down at Dogwood. They have some drinks there as well. Now, Macy and Mr. DLR had previously been at a brew pub testing the beers there, having samplers there. So they go down to Dogwood, they meet up, and then they go to, I think it's Tin Angel, another bar, and drink some more. They then get to Mr. Fankam's car. He drives them over to to DLR's apartment. She begins to cook some food for them, and he falls asleep on the couch. Probably passes out falling asleep on the couch, but falls asleep on the couch, and Macy falls asleep on the couch. Miss DLR goes to her bedroom and crawls in bed to go to sleep. A little while later, Mr. Fankam wakes up. He does what he's done many times before. He gets in bed with her, and he perceives, that she is interested in reciprocating sexual intercourse with him. Now, the jury, I candidly have to admit, the jury found against him in this case. But as the facts of his testimony shows, he believed that she was interested and they were having consensual sexual intercourse at that time. It's very clear that Miss DLR says no, and he gets up and he goes back into the living room and goes back to sleep on the couch where Macy's also located. The next morning, he and Macy both leave, and that's about what he knows of it at that point. What's important in this case is that to understand that there's text messages that are exchanged between Mr. Fankam and Miss DLR, and most of those text messages, he's explaining his position. She's saying, I was asleep. He's saying, I didn't realize that. I'm sorry, things of that nature. What's important in this case, though, that was brought out is that these text messages were just one-sided. I mean, Miss DLR, these were not text messages retrieved by the police through a phone dump and preserved and vetted and preserved. These were text messages that were held by Miss DLR, provided to the state in preparation for the trial.
Well, I know this may get into your other issue of due process, of the delay in the prosecution, because in your brief you argue pretty heavily because of this, and I believe it's 18 months delay.
Correct.
He did not preserve his text messages so that the full story could be shown here. That's part of your delay or due process violation. Is that correct?
That is the establishing of the first prong, which is my actual prejudice for a delayed prosecution.
But I guess my question is, I mean, he was aware from pretty soon after this event happened that night that she was making allegations that it was something other than consensual, correct?
Yes, you can read from her text messages that were introduced at trial that there was allegations that she was not consenting to the sexual intercourse. Yes.
And even knowing that, he still allowed those messages to be deleted or traded in with his old phone. I mean, he didn't preserve. I mean, it just seems like a reasonable person would think, I may be being framed here or set up. I need to hang on to this information, but that did not happen.
That did not happen, but let's also put it into whole perspective here, okay? Mm-hmm. This is September 27th of 2020. He's still around there until graduation of December 2021, and then doesn't move from Nashville until March of 2022. And granted, you might hang on to those messages and things for a while, but as time went along, it eroded any kind of fear or concern about being charged. Nobody came to him. In a rape case, most of the time a warrant is issued and a person's picked up, and you know right away, I got to get a lawyer, and the lawyer's going to say, do you have those text messages? Save those text messages. That couldn't happen here. And over time, he got another phone, and everything was lost. The other thing to think about in this case, and I was going to bring up, is that we're now living in that electronic digital age. Things are moving quicker. Mm-hmm. A lot of these cases, the Gilley, the Gray case, the Marion and Dykes case, they dealt with physical objects or people who hopefully don't expire in 18 months. But here we're dealing with electronic age and digital text messages and things. Snapchat, apparently according to the testimony, Snapchat is gone almost right away. So these things are moving much quicker, and so the perspective of what a delay is and how long a person can preserve the evidence without without invoking a due process and prejudice is much shorter now. But to get to your point, though, the messages, there were also these important messages that would have shown that Mr. Fankam was saying, hey, I don't want to get into a fight with you over this. I'm trying to explain and de-escalate the situation. And that's, but going to the point about the due process, and if you may I get some water? I'm getting dry in the mouth. So. As this court has seen several times, I get kind of wound up and get dry of mouth quickly. What I want to get to on this case in particular is that fundamental issue of due process for pre-accusatorial delay. And as Judge Witt wrote in 2008, after reviewing the Supreme Court cases, and also this Tennessee Supreme Court cases, United States Supreme Court cases, and other cases from this court itself, he wrote that as a result, the issue of who has the burden to establish due process violation is somewhat muddled. And it's muddled because of the tension between the delay of charges that creates a due process principles about giving notice to the accused in a timely manner that they're going to be charged, versus the very strict Marion Dykes standard that puts an almost improbable burden upon the defendant to have to prove an ulterior, that the state orchestrated a delay for a nefarious motive, for a motive to get an advantage over the defendant. And in the Gilley case by Judge Jones, Judge Witt, he looks very carefully at this analysis and weighing everything, including the Marion Dykes, which said, well, you've got to prove delay, then you've got to prove that there was actual prejudice, and then the defendant has to prove that the state did the delay in an effort to get an advantage over the defendant. And that was, and the growing trend today is to show that it should be more of a balancing test. Take all three factors and start balancing that. Balance what the explanation by the state is against the prejudice to the defendant. In fact, you can look at the cases that came out of this court as well as our own Tennessee Supreme Court and see that they are talking about that the most important, the most critical factor is the prejudice to the defendant, the actual prejudice that's occurred. And once the defendant establishes a delay in prejudice, then the burden should be on the state to show why, to give an explanation for the delay. As the Seventh Circuit explained in Seoul, the case that Judge Witt was looking at carefully, how can the defendant really know the reasons for the state for the delay? I mean, when you think about it, who really has the explanation for the delay? It's the state. How's the defendant supposed to show a nefarious motive on the state's part when it's the state who has the knowledge about why they waited 18 months to bring charges against Mr. Fankam? The first cases that were here in Tennessee was the Dykes case, which followed the United States Supreme Court case of Marion, saying that the three prongs and putting the burden on the defendant. Then we had the Tennessee Supreme Court pass the case of State versus Gray, where Judge Birch, writing for the court, said, under the circumstances of that case, we should put the burden on the state to explain why there was the delay. And in that particular case, he found that there was no good explanation for the delay, and the charges were dismissed. The state says that what the appellant is requesting is that the court should abrogate from the legal presence of Marion and Dykes, and I'm saying we don't need to do that. As we've looked at in the cases of Gray, Jones, Halleck, Tillery, and in our Supreme Court case recently of Caraco, you can still examine the due process issue and do a balancing test without abrogating from Marion or Dykes. You can look at you can see if there is prejudice, and if there is, then ask the state, what is the burden? Or what is the reason for the delay? Put the burden on the state is what I'm trying to say.
But that is that not abrogating from Marion and Dykes to put the burden on the state?
No, it's making sense. I mean, it actually is fundamental fairness and principles of having a fair play. Because in Gray, they did say put the burden on the state.
But not Marion and Dykes.
But not Marion Dykes didn't, which preceded Gray. And then the state says that Utley says, well, they uphold Marion and Dykes, but really Utley also upheld Gray in the language of the opinion. And so what you've got is this trend going forward where you can give due process considerations as well as without abrogating Marion and Dykes. It simply is asking who's going to have the burden of showing the reason for the delay. Judge Easter, I hope I got close to answering your question in a sense. I mean, and the Seventh Circuit is the case that really looks at that and says, we can still do this due process balancing without abrogating Marion. The other circuit, and I realize these are non-binding cases on this court, but the other circuit is the Fourth Circuit. And in there, they considered the Fourth Circuit in the Howe case said that the basic inquiry becomes whether the government's action in prosecuting after substantial delay violates fundamental concepts of justice and the community's sense of fair play and decency. And that's what we're advocating, is that in this, and I should mention, I'll get back to Judge Easter to your question there about why it does not abrogate from Marion or Dykes. In Marion, they made a specific point of talking about every case will have to be taken on the case-by-case basis. In Marion, they talked about that Marion specifically said that we cannot determine now when and in what circumstances actual prejudice resulting from pre-accusation delays requires dismissal of the prosecution. Going on, it says, this is going to be a delicate judgment based on the circumstances of each case. And that's what Howell talks about. Each case has to be balancing these, or each case has to be observed fact by fact to determine whether the Marion Dykes test should be applied or whether a balancing test under due process should be applied. I'm simply saying they run parallel with each other, not in opposition to each other. And let me make this point. Many of the cases that actually, or the Gray case, made the point that the state was unaware of the accusation when the state was unaware of the accusation for the period of the delay. And that's when the Supreme Court said Marion Dykes doesn't fit for this scenario. All right. Gray said we're going to go ahead and we're not going to apply Marion Dykes to this. We're going to do the balancing test. But turn that around. What makes even more sense? I mean, in a case where the state's unaware of the accusations and there's a long period of delay, the state doesn't have to prove, the defendant doesn't have to prove that there was an unreasonable, that there was improper reason for the delay. Turn it around. What if the state has the charges, like in this case? They're aware of it. Here, they were very aware of it by September 30th of 2020. The detective was investigating, paltry as it was, in October of 2020. And they go, and nothing happens till May of 2022? No charges are brought? Shouldn't then the burden shift to the state to explain why they sat for 18 months on this matter? Even the trial judge was questioning it when he was having during the bond hearing. And I better quit because my time's run out. So thank you for your patience.
Good afternoon, and may it please the court, Caroline Weldon on behalf of the state. Mr. McNally and I agree on much of what he's said in terms of the relationship between the victim and the defendant. They were friends, they were classmates in nursing school, and they did have a flirtatious relationship that the victim readily acknowledged when she testified at trial. That relationship sometimes involved drinking together, joking together, kissing, and they did sometimes share a bed. However, the victim was adamant at trial that they never had sex until the night of September 26, 2020. And that is where Mr. McNally and I differ in what happened in the victim's bedroom in her apartment on that night. That night, the victim woke to the pressure of the defendant on her back. Unbeknownst to her, while she was asleep, he had crept into her room, climbed on top of her, removed her tampon, and penetrated her vagina with his penis. The victim asked the defendant to please stop, and at that point, the defendant should have been put on notice that whatever he may have claimed that he thought was a consensual sexual experience was not. She was telling him to stop, which he did eventually, and in the days that followed, the defendant was put on even more notice of how the victim considered that encounter in her bedroom. She told him in a series of messages exchanged via Snapchat and iMessage that he should have known that she was asleep, that she was laying in her bed unresponsive to his advances, and the defendant responded that he likely had misread the signs and that he worried that he had gone too far, and he was concerned that he had upset her in some way. So again, this is very, very close in time to when the assault occurred. She told him to stop when she realized that he was on top of her, and then she relayed her concerns to him in the messages in the days very shortly after that night in her apartment. And I will limit my argument in response to what Mr. McNally has said on oral argument today, but I'm happy to respond to questions about any of the other issues. But I think it makes sense to just focus on his claim that the state delayed in indicting the defendant to gain some sort of tactical advantage, and whether the defendant suffered prejudice as a result of that delay.
Let me ask you, these text messages, they may be chat messages, I don't know, whatever kind of messages they were they sent before or after she went to the police and made a complaint?
They were sent before.
Before. All right, so if I understood it correctly from Mr. McNally, the September 30th, when they started the investigation?
The September 30th is this took place the evening of September 26th, and then in the days that followed is when these messages occurred. And on September 30th, the victim spoke with someone in the administration at their nursing school who suggested that she go to the hospital and receive a rape kit, which she did, which then started the process of her being connected with law enforcement through that hospital personnel.
Okay, so none of the messages were after that date?
I believe that the defendant may have continued to try to contact her after that time, but really the messages at issue at trial were the ones exchanged in the days after the assault. Yes, Your Honor.
All right, thank you.
And so just going through the Marion Dykes framework, in order to dismiss an indictment due to an undue delay, the defendant must show that there was a delay, that he sustained actual prejudice as a direct and proximate result of that delay, and that the state caused the delay in order to gain a tactical advantage. So applying this framework, the state acknowledges that there was a delay. There was an 18-month period of time that passed between the assault and the indictment. There's some conflicting information in the record about why that delay occurred. As Mr. McNally noted, during the source of bail bond hearing, the court asks the prosecutor, sort of in kind of an aside comment during the proceeding that said, why had it taken the state so long to bring charges? And the prosecutor said, in short, the crime lab. The crime lab was taking a long time. And that's really the extent of the information we have about the crime lab being a part of this delay. And it's, again, this isn't brought in a proceeding specifically addressing the timing of the indictment. It's a side comment between the court and the prosecutor when they're determining how the defendant is going to fund his bail.
But just so I'm clear, though, there was no DNA in this case.
Well, I think that the court can draw that conclusion because the state did not introduce any DNA evidence at trial.
So how could waiting on the crime lab been an excuse for this delay if there was no DNA?
Well, I think that, as I understand the defendant's argument, is that the state was using a purported delay at the crime lab as a reason to delay in bringing charges against him. That the state was kind of using that, I guess, as like a smokescreen to delay in bringing charges. But I think the more likely and more reasonable scenario is that the rape kit did not take place until 4 days after the assault had occurred. The victim was menstruating at the time of the assault, and I think that despite swabs being taken from various places on her body, that they were not able to recover DNA because she'd likely showered, or there just was no longer DNA on her body. So the DNA was not a part of the state's case at trial.
So they had all the proof that they had for trial at the time they decided to delay this and wait on the lab.
Well, I think this is reading a little bit between the lines in the record, but I think that they didn't have the results. They didn't have the results from the crime lab yet, and when the state received those results back, they realized that they were not going to be able to use those in the prosecution.
So the record will show, though, that some type of samples were sent to the crime lab for DNA testing.
Yes, the record would show that. Yes, Your Honor. Because the nurse who performed the rape kit testified that she had taken the different swabs from the victim. But they were not introduced, the results were not introduced in the state's case in chief at trial. And again, I think that's because they were not fruitful. Because if they were fruitful, they would have been introduced.
Certainly.
But given the time that had passed, I don't think that inconclusive DNA results are show much of anything. So yes.
And when was this started in the fall of 2020?
Yes, Your Honor.
So the pandemic started in the spring of 2020?
Yes, Your Honor.
Okay.
So there is the crime lab piece of the delay, but there's also a testimony that at trial about the difficulty that the state had in locating the defendant. And as the defendant acknowledges, he is from an African country. He has parents who lived in Texas. He was living in Illinois at one point. And so the detective and the investigator both testified that they had difficulty locating him at places that they expected to find him.
They didn't bother to check at the school where he attended and graduated in December of 2020?
The investigator said that he was unaware that the defendant was still there, and I'm not sure if that's possibly because, and again, this is reading a little bit into the record, but perhaps because of some sort of remote learning or apprenticeship in nursing school, I'm not sure. But they didn't find him despite trying to contact him, despite going to places where they thought that he might be, places of employment, and they couldn't find him. And so for all of those reasons, that is why the state...
They didn't bother to go to the school where he was going when this incident happened?
The investigator said that he did not know that he was at the school at that time. So, and again, the state acknowledges that there was a delay, but the defendant cannot show that the state caused this delay in order to gain some sort of tactical advantage over him, or that he sustained any actual prejudice from it.
Well, let's say, based on that comment, that this investigator decided to go to the school where the victim and the defendant were enrolled, found that the defendant was still in school there, talked to the defendant, and that would have placed the defendant on notice that something was going on, which might have resulted in him retaining the text messages that he said he erased, or the messages that he said he erased. Is that not prejudice of some kind?
I don't think so, Your Honor, because he had the notice from his conversation with the victim during the assault when she told him to stop, and in the messages in the days after. And as Judge Easter pointed out, any reasonable person who is being told to stop in a sexual encounter and then is exchanging the sorts of messages that they were exchanging in the days after the assault would have retained them and would have kept them, would have documented them in some way, would have kept that cell phone, and he chose not to. And so he was put on notice, and he says in the messages that he was freaked out. He expressed concern about their racial differences and fear of the Me Too movement. So it's not as though he was simply trying to de-escalate perhaps some sort of misunderstanding in their sexual relationship. She was saying, I did not consent, and he's saying that he is concerned about what's to come. And just to add a layer to that as well, the victim reported the defendant to the administration at their nursing school, and they were immediately put into separate classes. So he knew that this was a problem, and he had the ability to keep his cell phone, and he chose not to. And even if he had kept his cell phone, I don't know what sort of messages he could have had on there that would contradict the messages that they exchanged and the victim's account that she gave at trial. I'm not sure what other messages he envisions that could have been on there. The victim was adamant that they had never had sex before, and in the messages he acknowledges wrongdoing and says, I must have misunderstood, and tries to assure her that he did not finish inside of her, tries to assure her that he does not have any sexually transmitted infections. So he's trying to pacify her, I think, because he realizes that he has misstepped and that he is likely to face consequences for that. And if the state and if the court has no further questions, I'd ask this court to affirm.
I think Jen will.
Thank you.
Mr. McNally?
Thank you. I'd like to start off with, again, a person can reasonably believe that there's consensual sexual intercourse and later learn that their belief may have been mistaken, and it's not rape. And again, that's the standard here. Now, I'm not going to get into the sufficiency of the evidence, but that's the standard, and that puts into perspective part of his messages that he texts to her. I'm sorry, I didn't ejaculate. I don't have sexual transmitted diseases. It's an understanding to try, as he testified, as Mr. Fankam testified, he tried to settle this situation, de-escalate the situation with his classmate, with his friend. And we're talking about a friendship that's almost now, 2.5 years? Or, we're into 2020, or a year at that point, and going a little bit more. But I've never said that the state's explanation that we were waiting on the crime lab was a smokescreen. What I argued in our brief was that explanation to the trial judge was shallow, and certainly, if balanced against the prejudice to Mr. Fankam, did not outweigh that prejudice that occurred to him. Because we know that nothing at the lab had anything to do with the indictment or not. They had everything they used at trial by October of 2020, 1 month after Ms. DLR made her accusation. By the time the detective had picked up the swabs from the nurse at Skyline Hospital, had talked to Ms. DLR, had gotten the text messages, or actually she didn't even get those. Those were provided later in preparation for the trial. They had everything they were going to use in October 2020 to make a charging decision, and they didn't. And this explanation about the waiting on the crime lab is not, I did not say they were lying. I didn't say it was a smokescreen. I just said it was shallow and carried no weight as to a reasonable explanation for the delay. I'll tell you what is a smokescreen. It's this suggestion that anybody really tried to go find Mr. Fankam. Mr. Fankam was at that school. Maybe he's in different classes, but he's at that school. He's at the graduation a year and a half later. He's still in town all the way up through March of 2022. No one made a serious effort to go meet him. No one went to the school administrators and said, hey, where can we find one of your students? It's not that hard. Hey, we're with the police. Hey, I'm the investigator with the district attorney's office. I'm trying to find one of your students. Oh, he'll be in class such and such on Wednesday at 10 o'clock. If you read, it's 3.5 pages of testimony from the detective in the case on direct examination, and I don't remember how many pages, but Investigator Turner's testimony is just full of, I don't really remember, I don't know, I didn't read the whole file, I didn't really do that, I got some information from DLR, but it's just constantly, because he was just called off of the street to come testify in rebuttal, and he just said he couldn't remember much. I didn't get to show my actual prejudice in this, and I asked you to review my brief and everything, but the prejudice that I was going to show in this case from the lost messages is, one, that Mr. Fankam was unable to present his corroborating evidence to his testimony. And one may say, well, it's corroborating evidence, therefore, the lack of it may be harmless, because he actually testified to some of this. Yeah, I want to remind the court of the legal precedents both here in Tennessee and historically of the importance of corroborating evidence. It's been called the bedrock of credibility of witnesses. And in fact, we even have that jury instruction about credibility, about corroborating evidence that says that it instructs the jury that it's an important fact from all the evidence to determine whether the witness's testimony is corroborated by the other evidence. The second part of it was the failure to be able to put into full contextual background about the relationship between these two people before the incident occurred, to give credibility to his explanation that I believed we were having consensual sex. Thank you for your patience with me today.
Thank you, Mr. McNally.
Thank you.
All right, good job, good briefs. We'll take it under advisement and get this case out in the next few weeks. Call the final case, please. You need a break?
No, I'm good.
You all right? Yeah.